Good day, ladies and gentlemen. This is Dr. Frel, your professor.
Hello class, we're back. Our next topic would be on the security of tenure. These are the objectives of this topic. First is to discuss the security of tenure among employees. The second is to categorize the management prerogatives that employees can experience. Now, what is this security of tenure? This is a right of an employee and mandated by law that protects them from being unjustly terminated from employment by their employers. So, from the excerpts from Section 3, Article 13 of the 1987 Philippine Constitution, it provides that the state shall afford full protection to labor, local and overseas, organized and unorganized, and promote full employment and equality of employment opportunities for all. It shall guarantee the rights of all workers to self-organization, collective bargaining and negotiations, and peaceful concerted activities, including the right to strike in accordance with law. And they shall be entitled to security of tenure, humane conditions of work, and a living wage. And of course, under the Labor Code, it provides that employees shall enjoy security of tenure. This simply means that employees cannot be dismissed unless for just authorized cause. And an employee cannot simply be terminated because the boss does not like the way he looks. Further, class Article 279 of the Code provides for the security of tenure. That in cases of irregular employment, the employer shall not terminate the services of an employee except for a just cause or when authorized by the title of this book. And an employee who is unjustly dismissed from work shall be entitled to reinstatement without loss of seniority rights and other privileges, and to his full back wages, inclusive of allowances, and to his other benefits for their monetary equivalent computed from the time his compensation was withheld from him up to the time of his actual reinstatement. So, class, it is provided that no employee can be dismissed from work except for a just or authorized cause, and only after due process. So, what are these just cause? This refers to any wrongdoings committed by an employee, and this includes serious misconduct, you have willful disobedience or employers' lawful orders connected with work, gross and habitual neglect of duty, fraud or willful breach of trust, commission of crime or offense against the employer's family members, or his representatives, or other analogous cases. How about the authorized cause? This refers to economic circumstances that are not the employee's fault, such as the introduction of some labor-saving devices, or due to redundancy in the company, or retrenchment to prevent losses, or closure or cessation of business. So this mentioned class are not the fault of the employees but are being called due to some circumstances. So as far as just cause are concerned, there has to be some due process to be adhered to, such as notice to employee of the intent to dismiss and the grounds for such dismissal, the opportunity for the employee to explain his or her side, and the notice of the decision to dismiss the employee. Now let's distinguish a regular from casual employment. So, who are regular employees? These are those who perform activities which are usually necessary or desirable to business or trade of the employer. While a regular casual employee means a casual employee who is employed by an employer on a regular and systematic basis for several periods of employment, or on a regular and systematic basis for an ongoing period of employment during a period of at least 12 months. So again, class, they may serve for at least 12 months or 1 year of service, whether it's continuous or broken. In this, a casual employee may become a regular employee with respect to their activities. Now we have the other forms of employment. Let's start with project employment. This is defined as when an employee is hired for a specific project or undertaking, and the employment duration is specified by the scope of work and or by the length of the project. So this project employee are entitled to security of tenure, but limited to such duration. So they can enjoy the security of tenure within the period for the completion of the project. So in such a case, class, now project employees whose aggregate period of continuous employment in a construction company is at least 1 year shall be considered regular employees. So in the absence of a day certain agreed upon by the parties to the termination of their relationship. So, in one Supreme Court decisions, it was ruled that project workers are not regular employees, but they are considered as a coterminous depending upon the contractor of the project. But class under the Department of Labor Section 2.2 Order number 19, it provides that a project employee or a member of a work pool may acquire the status of a regular employee when this occurs. First is there is a continuous rehiring of project employee even after the cessation of the project. And second, the tasks performed are vital, necessary, and indispensable to the usual business of trade of the employer. Now we have seasonal employment. These are those who are employee are engaged in services which are seasonal in nature and within the duration of season. While a seasonal employee is the one who has been engaged to render work during a season. So in this case, the employer must be justified in hiring additional help via seasonal employees. They should work during the specified season only. And when we say season, this is a period inside a calendar year that requires some start and an end. So my question, class, is there any chance that a seasonal employee can achieve regular status of employment? Okay, of course, the answer is no. Although their services exceed 1 year, unlike casual employee. But there is some exception to this, except if their work are not merely for the duration of a season, but they are being rehired every working season. Then the third class is this fixed period employment. This is a project employment, but remember that not all fixed period employment is project employment. And as far as the contract is concerned, a fixed term contract is an employment contract by which an employer recruits an employee for a limited period of time. and it ends on the date fixed at the departure or in the absence of a precise term when the purpose for which was concluded was already concluded or achieved. So similar with project employee, fixed period employee may enjoy the security of tenure during the limited time of employment. But the labor code does not prescribe or prohibit employment contract with fixed period, provided both parties entered in agreement without force or pressure. Then the fourth one class is what we call probationary employment. This provisionary employment shall not exceed 6 months from the date of the employee from the date the employee started working, unless it is covered by an apprenticeship agreement that stipulates a longer period. So this provisionary period is in the nature of a trial period, where the provisioner seek to prove to the employer that he has the qualifications to meet the reasonable standards for permanent employment. And in cases where an employee is allowed to work after a probationary period, he shall be considered as a regular employee. Now, in cases where the employee did not pass the reasonable standard set by the employer, his removal shall not be deemed as violation of the right to security of tenure. So what are the limitations provided under the Supreme Court rulings regarding this? First is it should be in accordance with the specific requirements of contract. Second, there is a formal notice that is being required. Third is the employer's dissatisfaction must be real and in good faith. And fourth, there is no unlawful discrimination in the dismissal of the employee. Now, class, let's move with the management prerogatives. Even though the Constitution enshrines the rights of employee to security of tenure, our legal system also protects the right of the employer to certain prerogatives. So what are these prerogatives? When we say prerogatives, these are where employers and managers can freely supervise according to their own judgments. Its limitations lies in the policies, the rules and regulations of different countries, so that this prerogative must be fair and reasonable. So the first prerogative is the right to transfer. The right or the transferring of an employee from one place to another is not by itself unlawful, because it is within the inherent right of an employer to transfer or assign an employee in the pursuit of its legitimate business interest. However, this right is not absolute. Then the second is the right to discipline. This is the employer's right to conduct the affairs of its business according to its own discretion in judgment, which includes the prerogative to instill discipline among its employees and to impose reasonable penalties according or such as or including dismissal upon erring employees. Then the third is the right to promote. So this is where an employee, when we say the right to promote class, the employee is not bound to accept promotion, which is in the nature of a gift or a reward. But a refusal to be promoted is a valid exercise of a right. You have to be reminded by that class. So if the employer has the prerogative to promote, he has also the prerogative to demote. This right to demote of an employee falls within the prerogative, of course, of the management. However, due process is required in these cases because, like in the dismissal cases, this likewise affects the employment of a worker whose right to continue employment is also protected by law. And of course, the fifth one is the right to grant bonuses. Though it is most likely a privilege and not a right to receive a bonus. So an employee cannot demand to his employer to give him a bonus every time he does a good or a great job. It is part of an employee's job to do his best and deliver satisfactory work. However, there are some exceptions to this aforementioned general rule. Now let's discuss these prerogatives in more detail. First, the right to transfer. So this is, as we have mentioned earlier, the movement from one position to another equivalent position or rank. So most probably transfer do not use or employer cannot use this right to punish employee because this is unreasonable. So if an employer refuses to transform when it is valid, is guilty of insubordination or willful disobedience. So what is this insubordination? This insubordination in the workplace refers to an employee's intentional refusal to obey an employer's lawful and reasonable orders. The employer gives the order, and the employee acknowledges the order, and then the employer refuses to carry out the order. While willful disobedience means intentionally or willfully disobeying a lawful order, a directive, a statute or regulation, or a policy procedure. Then next we have the right to discipline. So how can we determine that there are violations committed by the employee? We are being governed by the proportionality rule. And what is this proportionality rule or the principle of proportionality? This is the idea that an action should not be more severe than is necessary, especially in war or when punishing someone for a crime. So in this case of proportionality rule, policies, rules, guidelines, and regulations on work-related activities of the employee. It must be fair and reasonable with corresponding penalties. Moreover, the employer has the right to impose a heavier penalty than that prescribed in the company rules and regulations. Then again, class, we have the right to promote. This is the advancement from one position to another, involving increase in duties and responsibilities, but of course, benefits and compensation increases as well. But remember, class, the employee has the right to refuse promotion. There is no law which compels an employee to accept a promotion. Then we have the right to demote. This is the reduction in position, in rank, or salary as a result of a transfer. And remember, class, that the right to demote, the exercise of the right to demote by the employer should be reasonable, and it should not be used as a punishment to the employee. And of course, it is a prerogative of the employer. And the last is the right to grant bonuses. So bonuses are type of compensation paid to an eligible employee in addition to a previously set hourly wage or contract amount or annual salary. In most cases, class, bonuses are based on performance, meaning if you do an exceptional job reaching your goals on a specific project, you might receive a bonus from your employer. But remember also, class, that to receive bonuses is not demandable right. it is a management prerogative. And it becomes an obligation only when it is stipulated in an employment contract of the collective bargaining agreement, or it is a company practice or policy, and or it is agreed as an additional compensation without any condition. And for your activity class, first prepare a collage showing the following, such as security of tenure and management prerogatives. And number two, describe your collage using at least 150 words. Okay, so that would be all class for today. Thank you for watching and see you in our next video.